But let me ask this now. I'm sort of understanding you doing due diligence on the person who you are buying land from.
Yeah.
What about if we are buying land from you? So what kind of due diligence do we need to do if an individual is buying land from a company? So like Goshen or Grand Acres?
Yeah, so most of it is exactly the same, except obviously for a company like Goshen Acquisitions, as opposed to giving you an ID, I will give you a certificate of registration for the business, right? That's the equivalent of an ID. I will give you the PIN certificate for the business. I will give you things like CR12s and CR8s, which are disclosures about the shareholding of the business. And it's on that basis that beyond asking for CR12s and so on, later on you can ask for copies of the ID of the directors and their PIN certificates, because they are actually in fact required when we're transferring to you. We have to surrender them to the registry along with board resolutions that we have indeed made a corporate decision to sell this property to you for a specific price, right? Because the company is treated as a separate entity from its shareholders and or directors. But all those documents are still required at the point of transfer. So you want to ask for them anyway, especially if you're working with a licensed advocate. It's done in a controlled and safe manner, because I can tell you for a fact, we will not share copies of our title with anyone who's interested in buying before they have paid us a reservation deposit and engage us formally.
I get
because then otherwise we'd have 1,000 people out there with copies of titles for absolutely no reason, and that's sensitive information. We don't want that floating out there for nothing. So if it's done in a controlled setting using the advocates, then you can ask for specific documents to aid in your due diligence. Yeah.
So now that you've talked about titles, so I mean, I'm beginning to understand the due diligence that needs to be done on a company, but you brought up the conversation on titles. Now, majority of people buying lands have never held a title, never seen a title, have no idea what to look for when they're holding a title. Where can they either A, get this information, or know that these titles are legit?
I mean, that's part of the due diligence through your licensed advocate of the High Court of Kenya. I mean, there's certain things that will generally be easily verifiable. With a certified copy, they can apply for a search and confirm ownership from the registry, just like we did when we were buying. They will also have the freedom to requisition a certified copy of the green card. If the lawyer is worth their salt, they will know to do that. As a standard practice, we do that when we never just deal with a search report. After the search report, we get a certified copy of the green card. And I recommend that for everyone, even our customers. Just do it as a formality. Even if you trust the seller, just get it out of the way so you have complete files. In the event of something else coming up later, you will be able to demonstrate beyond a doubt that you did your due diligence. You were diligent about checking out the legitimacy of documents, history of ownership, blah blah blah.
Okay, I've gotten the documents are legit from the seller, we are good to go. But when I'm on the piece of land and I'm buying 3 acres, my eyes have no idea what 3 acres looks like.
Yes. How
then do I certify that these 3 acres that you're telling me, for example, you said the amount of land that you have in Elementaita is
6.85 acres.
I mean, you broke it down to 0.58 acres.
Yeah.
How do you certify that? Like, what's the process of doing that?
So you as a buyer have the right and the option to get an independent survey done before you conclude the transaction. So by this point, you've paid a deposit. Ideally, you paid it to escrow if it's not an entity that's well known and easy to find. You want to pay as much as you can to escrow. In some cases, that's not always possible because the seller doesn't want to deal with escrow. In that case, you need to make a judgment call. Do I trust the seller enough to pay the deposit to them, Is there some accountability mechanism in the event that I want to pull out or not? But in general, it's best practice to pay funds into escrow.
When people are buying land from Goshen Acquisitions, do they pay to escrow?
In some instances, yes, and I'll explain the difference. So for transactions where we are pre-selling, like we did in Nanyuki, where we pre-sold half acres to a number of customers before the titling process of our subdivision was done, they paid funds to escrow. Even we were not comfortable taking their funds directly because we were not done with the titling process. And as it turned out, it was a wise decision because we've had delays with producing title deeds, and therefore for the buyers who feel like they want to pull out because it's taken too long, it's no fault of ours. We're having challenges with some authorities and we have to go through a legal process for that. But a customer may not want to wait, in which case they can pull out of the transaction, as is their contractual right to, and their funds are there to be refunded. Now, if they didn't pay to escrow, there's a high risk that we as a company who need to pay salaries and all manner of overheads, rents, and so on, have used your money to run the business. You decide you don't want to wait any longer, even though it's no fault of our own, and we're unable to refund you. That becomes a messy predicament. So it's always good to pay into escrow, especially when you're buying property that is not ready to transfer, right? So in that instance, we use escrow and we have no issue with it. In some instances, like we are in Imbuko, we're receiving funds directly because everything is ready to go.
You hold titles?
We hold title. The titles are held by the advocate. The sellers can easily confirm this particular fact with their advocates, and the transaction size is also not that big. If you're dealing with a multi-million shilling transaction, no matter how much you trust the other individual, you want things held in escrow until certain conditions are met and you're on the clear.
Okay, so when okay, let's go back to this Imbuko piece of land, and I'm just using this as an example.
Yeah.
In case anybody's listening. So when do you now put pen to paper? So when do agreements start getting signed? For example, when you are buying this parcel of land, and when does funds begin to get transferred? Yeah.
So to initiate a transaction, you have to do your due diligence. In my experience, due diligence will start before and complete after you sign a sale agreement, because certain things take time. And if you're sure you like the piece of land, the price is right, you like the owner, you've come to terms, you need to show good faith and goodwill by paying a deposit to initiate the transaction and to prevent the seller from selling to someone else.
Yep.
Right? Because while you're twiddling your thumbs thinking about this, that, or the other, someone else came along and pulled the trigger before you and the opportunity is gone. So you want to tie it up as quickly as you safely can by paying a deposit. According to the Law Society of Kenya's conditions for sale, a 10% deposit is the required minimum amount to make your sale agreement legally binding.
Okay.
Right? So you pay at least 10%, or if it's more, you and the seller have agreed. 10%, you sign a sale agreement approved by yourself and your advocate. It has to be professionally prepared. I have seen sale agreements that were a joke, that protected neither party. So you want to use licensed advocates, preferably those who specialize in conveyancing, as I've said a million times before, because they know what clauses to put in there for everyone's protection and safety. And it's at that point that you can say you have a live transaction.
Okay. What kind of protection as the buyer should I put in place?
So the most will have to do with vacant possession. That's an important one for me. If I'm buying a piece of land that happens to have squatters on it, I will make it the seller's responsibility to clear that matter out before the property is transferred to me and I pay the balance. Until then, I'm not interested. Squatter issues are messy and they can tie you up for years. So they have to guarantee that they will give you vacant possession, meaning there's no one on the property except yourself. Right? That's an important word. The other one is giving yourself enough time to complete the transaction. This is a matter of agreement or predetermined by the seller. For instance, when we have ready titles to go like we do in Imbuko, we don't like to wait more than 45 days for the balance, because typically within 30 to 40 days, we have received the Land Control Board consent to transfer and have already transferred the title, or have handed over completion documents to your advocate. And this is the third part. Completion documents, very important. It's a list of all the original documents required to effect the transfer from us to you.